Hi, I'm Carol McClarnon, and I'm here with my colleague Laura Taylor, and we're going to talk about what's ahead in 2020 with the DOL. The most important development this year for financial service companies will be the third version of the DOL fiduciary rule. At this point, there's more questions than answers about its effect. Will there be multiple iterations of the standard of conduct for providing investment advice, and what will those be? Does Reg BI conflict with or need special interaction with the ERISA rules? We also have the complication of state fiduciary laws and how ERISA might interact with those and whether ERISA will preempt those laws. Will compliance with Reg BI cause one to become an inadvertent fiduciary under the new fiduciary rules? There are additional consequences of becoming an ERISA fiduciary beyond the standard of care, such as co-fiduciary liability and the requirement to comply with conditions of prohibited transaction exemptions.
Another item on the Department of Labor's agenda for 2020 are regulations surrounding proxy voting. In the spring of 2019, the President issued an executive order about growth in the energy sector, and as part of that, he asked the Department of Labor to review their proxy voting guidance. The goals of the proposed rulemaking is really to protect the interests of participants and beneficiaries, and really looks at three different ways to do that. One is by addressing conflicts of interest between proxy advisory firm recommendations and the participants and beneficiaries. Another is ensuring that proxy voting decisions are based on the best interests of the participants and beneficiaries. And then the third is making sure that decisions are actually made in the interest of these participants and beneficiaries. We're going to keep an eye out for that in 2020 and see what comes out.
The recently enacted SECURE Act is going to require some regulatory guidance from the Department of Labor. In the first place, there is a new concept, finally, of open multiple employer plans, or MEMPs, and the concept of a pooled plan provider who takes over the plan administration and other responsibilities from the employer. A pooled plan provider can be any person who agrees to comply with the IRS and Department of Labor rules. Another new development is lifetime income disclosure for individual account plans, such as 401ks. These disclosures will require the plan sponsor to show what the benefit would be with the account balance if it were paid in the form of a life annuity. The Department of Labor is required by the SECURE Act to issue a model lifetime income disclosure statement. This will require coordination with other regulatory guidance.
So our final thing that we wanted to touch on is that the missing participant guidance is still missing. There's been an increased focus by the IRS and Department of Labor on missing participants over the past several years. And the Department of Labor has actually been doing some missing participant audits. Plan sponsors, employers have sort of grown frustrated with the fact that they are having these audits happen and there's investigations and they still don't have any guidance on what they actually need to be doing in order to make sure that they've adequately protected these interests. In 2019, the missing participant guidance briefly appeared on the regulatory agenda, but it has since gone missing. So it's unclear if this is something that the IRS or the Department of Labor is going to address in 2020. Thank you for joining us. For more information on asset management in 2020 and other bottom line videos, please visit eversheds-sutherland.com.